As stated, we're here in the case of Martin versus Tovar, and it looks like the attorneys are ready, and you are Ms. Tyler? Yes. And it's my understanding Brandon Lobberecht will be arguing for the appellee. Okay, Ms. Tyler, you may begin.
Good morning. May it please the court. Justices, Brandon, I'm Leanne Tyler, and I represent the plaintiff in this case, Sherry Martin, who is seated right here in the front row with the blonde hair. This case is a very troubling case. I think I quoted in my brief FDR when he said, "With great power comes great responsibility." What we are deciding today is that whether police officers who serve our community should be responsible, or who should be responsible in reference to abuse of that power. Should it be borne by the victim, or should it be borne by the police department? Before I get into the facts of the case, I do want to point out there have been some decisions in this area since the briefs were done by the attorneys. In particular, there is a decision, and the reason I'm talking about it now out of order because it's important that you know about this decision. It comes out of the it comes out of the Federal District Court in New Jersey, and it's the case of PJ versus City of Jersey City. And the facts are an 8-year-old boy and his friends had an encounter with a police officer. The police officer told him he was going to arrest him and members of his family if he did not meet the police officer later. He met the police officer later, and the police officer raped him. And what is important about this case is because in defendant's brief, they rely on restatement second of torts, having been coming out of 1957, having been changed in restatement third, and a lot of these cases are decided under restatement second of torts in the aided and agency theory that I'm going to get into. Particular two important cases, Sherman and Pena, Sherman being the main one. But
on that point, we have typically followed the restatements, and typically we have often gone with the most recent one. And the aided by agency theory is set forth in the restatement second, but the restatement third does not have it. And there seems to have been some intent to not carry it forward. And so why should this court go with a legal theory that it would seem that the folks at the ALI are now abandoning?
you're absolutely right, but the most significant Iowa case kind of talking about restatement second in this area, of course, what is the Haskell-Hoff case, which talks about Ellerth versus Burlington Industries and Fairhager versus City of Boca Raton, who were the idea of the aiding and agency theory that came into sex harassment law. And
adopting that theory, it's more just saying here's this Supreme Court authority in the area of sexual harassment. And I mean, following up on Justice McDermott's point, we normally follow the current restatement, and there, if you try and look up the aided by agency language now in the restatement, it says something like, this provision was never really approved by the ALI membership, and it's now been superseded. So, you know, why shouldn't we go with the consensus of what seems to be, the people who, specialize in this area, in this agency law area?
very good question. And first, I'll address your first point, which is you're right. The case under Iowa Civil Rights Statute, Haskell-Hoff, does only discuss it in dicta. It's not what the case is holding. It just discusses it. Now, and that's restatement second of torts. Now, this is why I bring up this New Jersey case, because it talks about restatement third in the context of a situation like this.
That case? Yep.
It is 2022 Westlaw 169-49544, and it was decided on November 15th, 2022, PJ versus City of Jersey City. And I believe in that case, here's kind of what they say. Okay, they talk about the American Law Institute's criticism of the aided by agency theory and restatement second of torts, and it goes to that when it redrafted restatement third. And it says, restatement third's comments explain that the aided by agency exception was omitted as a distinct basis for various vicarious liability in favor of a more fully elaborated treatment of apparent authority and by the duty of reasonable care that a principal owes to third parties with whom it interacts through employers and other agents, okay? So a more elaborate treatment of apparent authority and by the duty of reasonable care that a principal owes, seems to get into foreseeability there. But I'll quote the actual change in restatement third that they go on to talk about, and it's in section 708. It says, and a principal is subject to vicarious liability for a tort committed by the agent in dealing or communicating with a third party on or purportedly on behalf of the principal when actions taken by the agent with apparent authority constitute the tort or enable the agent to conceal its commission. Okay. The apparent authority theory survived and arguably expanded slightly with the addition of the final clause, or enable the agent to conceal the tort's commission. And it goes on to discuss the Applewhite case, which was the case decided in Louisiana, I think the first case in the country holding police departments liable for sexual assaults while on duty. And that was the case where the police officer and it was like a guard, he wasn't a full-fledged officer, segregated a young lady from her companions, put her in the car, and one of them had oral sex with her and raped her, and the other one raped her. So that was the case that one of the first cases in the country to hold police departments liable.
So if I understood your briefing right, though, you're asking that we recognize an aided by agency theory and not this, at least as I read your brief, this kind of broader apparent authority, negligent supervision type theory.
This case was decided after my brief, and Iowa really hadn't decided anything there weren't many cases under restatement third, except for the Powell case, which was also decided after the briefing. That was Powell was decided June 24th, 2021. This case was decided, again, November 15th, 2022.
Different. I mean, I just want to clarify, that is a different theory of liability than what was presented in your brief, which was the aided by agency theory.
Presented a more general tort theory for foreseeability and instrumentality. And under this foreseeability, that's why it falls into this restatement third, where it says, where did I do my case? Okay. It says, when the actions taken by the agent with apparent authority, let's see here, reasonably, when apparent authority theory survived and arguably expanded with the addition of the final clause, or enable the agent to conceal the commission. Act in ordering him to, okay. It reasonably expected is the key language. I can't find it right now because this is fairly new, but it's, yeah, reasonably expected is the key language, and that's where we get into the foreseeability, because this officer had a 20-year record that was like training day, and these guys covered it. The Muscatine Police Department, he actually, what was the word? He undermined investigations in performance appraisals after performance appraisals, undermined investigations, destroyed evidence, lost evidence, tainted witnesses. Yes. I'm impassioned about this.
There's no question that this officer's record was very poor, but as it relates to foreseeing some sort of act like this. So he is promoted, he is demoted, but for the police force to have viewed that the possible risk of keeping him out there was that he would commit an intentional sexual assault while on duty strikes me as a pretty big leap based on the other things that he had done. So poor police officer, yes, but foresee this act? Connect that dot for me.
And connect that dot. Specifically with an incident occurring in September of 2010. MK, who is a banker at the Citibank in Muscatine, witnessed an incident where a young lady was, basically what happened is she was being followed by a police officer. She accelerated, she left, what can I say? She was drunk, well, let me step back. She's driving while intoxicated. She had a wreck. She left the scene of an accident. Now, that's some jumps there, but what happened after she did that, she went into a landscaping company owned by this vice president of the bank and asked to use the phone. When she used the phone, she called Officer Tovar and asked him to pick her up. Now, she said that she'd been followed by another police officer, that she had passengers in her car, and she had a wreck, and she left the scene, and the banker said she appeared to be highly intoxicated. Her behavior was bizarre. She appeared to be, he had several indicia that he thought that she appeared to be on drugs. So she calls Officer Tovar, who comes and gets her in a private vehicle. This citizen of the community who's a banker who witnesses this incident for 15 minutes, probably, max, because she saw her on the phone, saw her behavior after she talked to Tovar, and saw him come pick her up, knows that this police officer is not a clean cop. He knows that, so he reports it. He reports it to Officer Snyder and files a citizen's complaint. And they come out and they see him. And Officer Snyder, who then is a lieutenant, later became the captain supervising Tovar. He comes to talk to this banker, and the banker says that Officer Snyder acted offended that he bothered to report it, marginalized the incident, and was angry at him because he was even involved.
Isn't that also a big leap? I kept waiting for you to say, and I was waiting for the other shoe to drop. So he picked her up in an unmarked car, probably his own private car. Was there any allegation of rape of that victim?
Because they didn't investigate like everything else.
Evidence that there was. So that to me is still a leap. What Justice McDermott was asking, bad behavior, yes. Picking up people, maybe taking them home. Old school, unfortunately, law enforcement sometimes would do that. They would take somebody home. That's also bad cop. But how do you leap to the incident that led to today? What in the history would have indicated that the law enforcement agency should have been on notice?
Gone out to her, when they investigated, they gone out to her house to talk to her, they might have known whether he raped her. Instead, he brings her in the police station by her allegation. Now, they didn't know this, but cuffs her to a desk and sexually assaults her in the detective department. Now, look, what you're supposed to do when somebody has an OWI, helping them conceal it under those circumstances is aiding and abetting a crime. That's a crime right there.
Oh, that was an example he asked for. But like I said, I don't think it helped leap to where we were. Is there anything else that's sexual related? I mean, you have innuendos and allegations, but not in the evidence.
I guess what I have is he had an affair with a county attorney who was working on cases he was involved in. That's highly inappropriate. I mean, I've got that he had some kind of affair with a chiropractor who was arrested for theft. He had a domestic abuse.
Let me get to the more criminal activity.
I think this undermining investigations just leaped out to me, because why would you do that? If I'm internal affairs at a department, why would you do that?
Like that, though.
There's no way this guy's going to walk into work and say, I'm going to rape somebody. But when you don't follow up and check on him, when he's doing these various activities that are non-conforming, like undermining investigations, destroying evidence, not following up on particular cases, you have to smell a rat, and you should look to that. You should look there. And what I want to tell you about this law, too, is I'm just about done. It protects clean officers. Look, nobody wants to work with this guy. It's got to be incredibly stressful. I mean, nobody wants to work with somebody who's violating the law. So if you changed it, it would protect it would, or not changed it, but if you,
Negligent retention theory directly against the city, or is your theory just vicarious liability?
no, it was foreseeability based on this horrific record that he had at the city over 20 years. And also, you need to know his last performance appraisal was nowhere to be found, the one immediately before the rape, 2011, 2012. They never could produce it, and they have no reason. So,
That point, because I think I had the same question. I thought the claims were sexual assault, battery, intentional infliction of emotional distress, false imprisonment, and invasion of privacy. And the claims were settled, or there was a offer or confession of judgment from Tovar. And that the city's liability here was only vicarious for those claims that I just listed. There wasn't a cause of action for negligent retention, negligent supervision, negligent hiring. Or am I missing something? That's the pleading.
vicarious liability and foreseeability based on his record. That's correct. And the only confession for judgment is on assault and battery. That's it.
I just listed. Okay.
Like I said, the confession is for those two by Tovar.
It's to come back.
Very much.
Thank you, Chief Justice. May it please the court, counsel, for the high school students in the room, my name is Brandon Lobberecht. I grew up in Burlington, Iowa, graduated from Burlington Community High School in 2006, so a little bit later than some of the justices here. My office represents the city of Muscatine in this case. Obviously, Tovar is one defendant. The city of Muscatine is also a defendant. To Justice McDonald's point, it is exactly right. There were 5 independent or separately enumerated tort claims that were pled by the plaintiff against Tovar individually, but the only claims that were advanced and pled against the city of Muscatine was a claim of vicarious liability, and specifically pursuant to Iowa Code Section 670.2, part of the Iowa Municipal Tort Claims Act. And what that act says, and I think this court is aware of it, but I'll go through it anyway, is that municipalities are subject to liability for their own torts and for those of its officers, employees, or agents that are acting within the scope of their employment duties. The reason why that's important in this case is that it's easy to get confused between separate independent theories of negligence or liability and what vicarious liability is. The Municipal Tort Claims Act, if I recall correctly, was enacted and became effective in 1967. And it's a departure from common law. Common law prior to that point in time was sovereign immunity to municipalities. So when this was enacted, it was a departure to try to bring it into more of the common law that applies to other types of employers or other types of individuals in the state. But it adopted essentially the same test that has existed in common law in Iowa, which I think we cited cases in Iowa going back to the 1920s, that vicarious liability, because it's imposing strict liability against an employer, not based on anything independent that the employer did, that it has to be an act that's done within the scope of employment. And generally what the scope of employment means is you're looking to see if the conduct committed by the employee was authorized by the employment or is incidental to where you look at the conduct and you can say this seems like something that would flow naturally from the employment.
Assume that the city knew about the later testimony that BW gave about being assaulted by Officer Tovar. Would that change the result in this case? In other words, should they have foreseen, had they known that this might happen again and that permitting him to drive someone home alone late at night might lead to an assault like the one that happened here?
There's a couple of things to kind of break down in there, and that's part of the reason why I think it's important to separate out independent negligence claims from vicarious liability. From a vicarious liability standpoint, under the statute that's here, which is the court's obligation is to interpret, apply, and enforce it, the answer is no. Because you're still looking to see was the conduct within the scope of employment, and I don't think there's any employment in the state of Iowa that it can be pretty reasonably or fairly argued to say that an employee is somehow authorized either generally or incidentally to commit a felonious sexual assault against another. I don't think that is part of any employment in Iowa. When you're talking about an instance of independent liability, so whether it's negligent supervision, retention, what have you, that's when you get into foreseeability. And part of the confusing thing, and it's probably not articulated as well in our briefing as it could be, but of course I get the time, 2.5 hours to drive from the Quad Cities to here and spend last night to read over some more of this stuff. The basis for this liability comes from the restatement second of agency, not torts, agency. And in particular, you look at section 229, it gives a list of factors of these are the things that you're to consider if something's in the scope of employment. The bad part about the restatement second is that I think it was drafted 1958. And a lot of times the restatement has provisions and then it has commentary. And of course, the court likes to, and I think litigators too, like to look at the commentary to see you've got this provision, what does it mean? The commentary is going to shed light on that. There's no aspect of section 229, which is what this court's used before in Iowa common law cases. There's no aspect of it of foreseeability. And the reason why there's no aspect of foreseeability is it doesn't come into play. That's an element that you consider in independent negligence claims. So when you have an independent tort that's got the factors of a duty, a breach of duty, foreseeability is part of the breach of duty analysis. I think the court has gone through that before. What I would suggest the court do to help understand this a little bit more is look at the counterpart in the restatement third of agency that goes to 229. So restatement second, 229, the counterpart in the restatement third, it's not cited in our brief, and I apologize for that, but it's section 708 of the restatement third of agency. It goes through in the commentary about foreseeability, and one of the things in particular that it cautions against looking at foreseeability in the context of what we know in negligence cases. I'll just quote from this: foreseeability has a well-developed meaning in connection with negligence, and to use it additionally to define a different boundary for responding at superior risk confusion. And the reason why that is that we're not looking to see foreseeability. The two elements in a scope of employment test is there an employment relationship, and then was the act done in the scope of employment?
Interpretation of scope of employment, the employer really can't be liable for intentional torts.
Not to say, it doesn't go that far. And the restatement sections talk about that, I think both restatement second and the restatement third. But I think the restatement third in that 708 really gives, or I apologize, maybe it's 707. It is 707. The restatement third and 707 gives a little bit more background and commentary as to what it means by scope of employment. And essentially, it's kind of a smells like, sees like test of you're going to know if something is incidental to the employment or not. But it cautions that you can have intentional conduct. It doesn't necessarily remove it from being within the scope of employment. They give examples like if you've got somebody who's hired to transport a cargo from A to B, if they choose to speed or drive on the wrong side of the road, that may not be removed, so far removed away from the employment because they're transporting the goods. You're expecting that they're going to transport the goods.
Right? I mean, so what are the examples of intentional torts that you would find are within the scope of the employment?
Well, so the ones that they talk about in the restatement a bit more probably pertain to, let me back up for a second. I think you're always going to be hard-pressed to find intentional torts that meet that test.
And what opposing counsel says is you have to allocate the risk of loss to somebody here. And scope of employment means during work. You know, I mean, the guy, if I understand this right, Tovar is in his uniform, correct? He responds to a crime scene, right?
Stop, yes. Yep.
He transports somebody from a traffic stop in a police car. And then he rapes her while he's in uniform, performing his duties on the clock with the city. He's being paid for this time, correct?
Yes, correct.
That seems like a pretty bright line rule. And I get it. That's not what his assigned duties are, but he's performing them while he's performing as a police officer. Why can't we just say that? And then the city can bear the burden of loss because he's clearly employed at that time.
You can't say that is that, well, I think there's a couple of reasons. Number one, we've got to look to what our prior case law says about scope of employment, and then in addition to that, the prior case law looks to the restatement provisions. And what those things are going to tell you is that some of the factors in determining whether or not something's in the scope of employment, some of the big factors, and especially applicable in this case, is whether or not the tort act committed by the employee is a serious criminal offense. Because, and especially in a case like this, when you have a sexual assault, we're looking to see what is the connection between what the employee does and any benefit or purpose to the city. When you make a deviation or a substantial departure, and it's what both the Iowa case law says and the restatement provisions say, when you make that deviation or departure from what's expected in your conduct to do things that are personal in nature or that are so startling that nobody could reasonably say that that is incidental to your employment duties. And even in the cases, if you look to the outside jurisdictions that were cited by...
Isn't, in this case, his job was to walk an intoxicated person to her door, open the door for her, and potentially, I guess, make sure that she gets safely inside?
Disagree with that. I think what the record supports is that the policy or the custom or practice of the Muscatine Police Department is to give individuals rides home. I don't think that there was any authorization to say you walk them to the door. But even if that's...
Happened inside the jail. Let's say she wasn't being transported home. She was the intoxicated driver. I know it's not this case, but let's say the assault happens in the jail, post-booking, post-arrest. Is that in the scope of employment if the jailer or the police officer conducts a rape or a forcible assault inside a jail facility while somebody's under arrest?
The answer to that is no. And the reason being, and what I was trying to get at before, is when you're looking at these various factors, the problem that you have with these sexual assault type cases is that the motivation for the individual to commit that act is purely personal in nature. Whether it's for self-gratification, self-desire, lust, it has no basis with the employment other than...
That 708 of the restatement, which I have in front of me, because that's the provision that we're supposed to be working with according to the city in this case. All right, it says, a principal is subject to vicarious liability for a tort committed by an agent in dealing or communicating with a third party on or purportedly on behalf of the principal when actions taken by the agent with apparent authority constitute the tort or enable the agent to conceal its commission. Now, if you go to the first part of this, on or purportedly on behalf of the principal, clearly the sexual assault is not on behalf of the principal. It's purely Tovar's committing a crime. But the second part says, and this is what Ms. Tyler was talking about, by the agent with apparent authority constitute the tort or enable the agent to conceal its commission. You do have this scenario, as Justice McDermott mentioned, that the city of Muscatine has this policy that it's okay for police officers, even a male police officer and a female passenger, to personally escort a passenger to their home, not for any law enforcement reason, but just as a convenience to that individual. And that, one could argue, enabled the agent to conceal the commission of what happened after that. So if we apply sort of that second part of the language, doesn't she have Ms. Tyler have something to work with?
I'd still say no, and part of the reason is when you're talking about the apparent authority, there's no facts in this case that suggest that there was any act of apparent authority. So there's no conversation, no evidence of conversation between the officer and her of...
Is obviously not once they get in the hotel room, but when he's bringing her back or bringing her to the hotel room, right?
There's apparent authority, but again, you're talking about a substantial deviation or departure from whatever that authority is.
Parent authority, we're talking about with actually both of the justices. I want to hone in on that. You're making it sound like all he had to do was drop her off the door. You got a drunk woman, And I think then he's going to get himself in a tangle if he just plain drops her off, and then somebody else attacks her between the hotel door and her actual door. And I know as a young girl growing up, whenever I got dropped off, my parents wanted to make sure whoever was dropping me off made sure I got to where I needed to be. So isn't there more to it than just plain a drive-by, drop them off?
Correct, but again, what we're talking about is a spectrum of events, and at some point in time, you get this substantial deviation. And where that comes into play is that even if you can say reasonably that the authorized activity was to take her back to the hotel and make sure that she gets inside of her room, once he crosses that threshold, that's when he's engaging in personal conduct that doesn't benefit the employer.
Yeah, but if you're working, and maybe that's what 708 means, but if you work with the second part of the language, I mean, the apparent authority is what enabled him to get her to get in his car in the first place. I mean, I very much doubt Ms. Martin would have gotten in the car of some bystander to take her to this hotel. It was in the middle of the night, I think. If it hadn't been for the fact that it's a police officer and there's an element of trust there, right?
That's correct. I mean, there is certainly some authority to do certain things, but again, employers aren't strictly liable for anything and everything that an employee does. And this court's addressed it before in the cases that we've cited to with the Godar case and Lindemulder and Rineker. The fact that there is a connection, however small the nexus is with the employment, doesn't impose strict vicarious liability. Could it give rise to arguments?
I mean, it seems like the scope of employment is meant to ensure that the municipality is not liable for something that's happening kind of off duty, like the person's personal stuff. So in this case, for example, if Tovar had met this woman, went home, came back 10 hours later, he's off duty, and it's basically a purely personal thing at that point, then the city shouldn't be responsible. But here he pulls up in a city vehicle, in a city uniform, with a city badge, he's armed, right? Correct? And pursuant to a city policy, he transports her, which she probably wouldn't go, but for the fact that he is a police officer and he agrees that he's gonna provide safety to her and get her home. He's basically cloaked with all of the authority of the municipality, and he exercises that authority for the purposes of transporting her somewhere. And I totally understand that it's not in his training or his job duties to commit criminal acts, but he did. And he did it on the clock under the city's authority, with the imprimatur, the public kind of imprimatur of their authority. So I'm not sure why that's so hard to say that's within the scope of employment.
Your Honor, I'm out of time. Can I respond?
Bet.
So I think what's kind of getting lost there is that I think you're kind of making an argument or a justification of if it has some sort of close tie to the employment itself, that's all we need for scope of employment, which I think does a great disservice to all employers across the state. The argument that's been raised and tried to be justified in some of these other states, which I will point out, and we pointed out in our brief, there's 6, apparently maybe 7 jurisdictions that have adopted it. Only 3 of them even looked to the restatement. The other 3 developed this law either out of their own common law or for public policy reasons. That's not typically how it works in Iowa. But the issue...
This is kind of the first question then. So as you're reading this statute, an intentional tort doesn't advance the employer's interest really ever. So give me the example of the intentional tort that remains actionable under 670.2 with respect to the city.
It's difficult because we've got a lot of different intentional torts. Potentially where you can get into something like that is maybe an invasion of privacy, where there is something generally authorized or incidental to an employment that an employee takes too far and it constitutes an invasion of privacy. I think what I'm getting at is that when we're talking about sexual assaults, it's very difficult to rectify that and apply that and to say that that somehow has a nexus other than just being tied to the employment by location or happenstance, or you're able to meet and acquaint with somebody, which is, it's come before this court before. And Godar and some of the other cases, the Iowa Supreme Court and Godar said, look, the fact that you meet somebody because of your employment and it gives you the means to either meet them, or the fact that you have a place of employment that allows you to assault somebody else, doesn't mean that your actions as the employee is done on behalf of or in the scope of your employment for your employer. In further example, if we talk again about a truck driver driving from A to B, gets in a road rage accident on the freeway during stop traffic, gets out of the vehicle and shoots somebody, fatally injures them. You can make that same argument as you would with a police officer. Well, you're in uniform, you're driving your truck, it's on the way to where you're driving the truck. But I don't think realistically anybody would say that that seems to be something that's benefiting or furthering the interests of the employer. And I don't think, with respect to police officers, I get the justification. Honestly, that's a legislative issue. If that's how the legislature wants to go about redefining the scope of liability for police officers, it absolutely can. But what this court's obligated to do is follow what 670.2 says, follow what the scope of employment says, and we believe that the district court got it correct in this case, that the acts in this case are so far removed, they're outside the scope of employment. There is no vicarious strict liability that can be applied to the city. We're not dealing with independent negligence or tort claims. That's a different issue for a different day. And on behalf of the city, we'd ask that this court affirm the district court's ruling on summary judgment. Thank you.
I did not plead negligent hiring. He was hired in 1993. I don't have any evidence that that was negligent. And I didn't plead negligent retention because there are no cases holding police departments liable or cities liable under that. I did plead, however, foreseeability and instrumentality. And in this case, even under restatement third, the duty of reasonable care. It was not reasonable care to leave this officer on all these years with this record. It was not. He was going to do one crime or another. And remember, reasonable care with the police department is very different because it's the only interaction that's immediate that the public has with government where you can be arrested and incarcerated, or you can be basically deadly force be used against you. So anybody who's stopped by a police officer and they say, give me a sex act, if they want to live on or don't want to go to jail, they're going to consent. And that makes that very powerful. It's not like other government. Everybody else is tempered because there's time, there's due process, there's all these things. It's immediate, it's in the field, generally the dark of night. And there are many cases like Sherry Martin's cases. The other thing I want to point out is Montana did address a very similar analysis very recently, August 16th, 2022, that it seems to employ restatement of third. It is 409 Montana 505, April 19th, 2000, and it is LB versus United States of America. Okay, and it's a reservation case. And it's a woman arrested for drunk driving, and he goes to her house and rapes her.
Our case law, to find in your client's favor, do we have to overrule Godar versus Edwards, Giudice, and if not, how do we distinguish those cases?
Reasonable care is a lot different with a police department than it is in any other employment situation. I don't care if it's a psychiatrist and a patient, which is an employment, because the other things that can be done to you are like, oh, you get a bad grade at school, or you flunk out, or the psychiatrist gives you a bad report as far as progressing. It's not, you can be killed, deadly force use, that's legitimate, and you can be taken to jail. Additionally, you're not even supposed to peaceably resist a police officer. No resistance, none. And this gentleman was on duty. He got a call in his car that he went to afterward, Tovar. I want to say that. And then, he went with his lights off, secret that he had been with Martin that long.
So under your theory, the police officers are different, and so that allows us to get beyond Godar. Are you proposing almost a strict liability type of standard, or how do we draw the line to distinguish this from strict liability?
Good question. And under restatement third with a reasonable care, I think you can do it on foreseeability where you've got a horrible record. The problem that I have with this is that I think this record, probably the department, I mean, I'm not going to say they're bad, but the performance appraisal's gone. You know, when somebody undermines an investigation, there should be another investigation and find out the reason why. And it could be they're tampering with witnesses, having sex with witnesses. They could be stealing. They could be taking, you know.
Back, I think, to where Justice McDermott asked you earlier, is how foreseeable then? Is it just that, you know, he had one bad performance, or he had 20 years ago? Is it how? And I understand in this case, but I'm just trying to, you know, we're a lot of times in the business of drawing lines. And so I'm trying to decide, how do we connect those dots, and where is that line here?
Took her home, there were several officers on the scene, including Captain Snyder, and they elected to have him take her to the hotel room 2 blocks away from the fast food place where the boyfriend was arrested, and she was a passenger in the car. You can see them all on the videotape. You can see things. It's not, you know, in this case, but I want to thank the Attorney General of State of Iowa for prosecuting that case and sending Tovar to prison, because that needed to happen.
About the text of the statute. So liability arises here under 670.2, which makes the city liable for actions done within, quote, the scope of employment, correct? Restatement second of agency 219, which I think is what these kind of aided by agency theory arises out of, right? That's the restatement. Comment E states that this aided by agency theory enumerates situations in which a master may be liable for torts of servants acting solely for their own purposes and hence not in the scope of employment. That's what the restatement says. So if we adopt your theory of liability, how do you square that with the text of the statute?
Well, you know, I guess it would be, and that theory would be an extension of the statute to some degree. But if you go to my second theory, which is foreseeability and instrumentality, that fits in with restatement third and what's reasonably foreseeable. And why it was reasonably foreseeable is because of this horrible record that this man had. I mean, and again, this protects clean officers. How would it be to work with this guy? Your stomach would be upset every day. It's like out of the movie Training Day. It'd be terrorizing. So it protects, it's good for everybody. And, oh, okay. I have 1 minute. Okay, sorry.
Time is now growing.
Apologize.
And it's a quick summary.
Well, in summary, I'm not asking you adopt this in every employment situation, even ones where there may be coercive abilities, like with the psychiatrist and the patient, or like with the teacher and the student. That isn't appropriate. Reasonable care in the police world, okay, police department world, is heightened, again, because of that immediate contact. And a lot of the cases around the country discuss that immediate contact and that power, and no supervision of that power. It's usually just the officer and the arrestee. And I think that's the reason I'm asking for it. And I do think it can square with restatement third. Neither my opposing counsel or I had opportunity to look at that before we briefed with the new cases. He did brief the Powell case that uses the same, a similar analysis to the Montana case. Powell is an Illinois case. Okay. Anyway, thank you. I apologize. Thank you so much. I appreciate your time.
Of Martin versus Tovar is hereby submitted. We are going to take a brief break, and we will return for our third case, Des Moines Civil and Human Rights versus Knieven.